Hello, 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 wealthy trustees. I'm super excited to see you guys. So tonight we are having a live Q&A so that I am able to answer any and all questions that you guys might have. So the first thing that I want to do is I am going to respond to the frequently asked questions. And then after that, I will open up the floor so that you guys can ask any questions that you might have. Hold on one second. Let's see. Okay, let's let some people in here. There we go. Okay, perfect. All right, but before we get started, how is everyone? How is everyone doing?
Fine, fine.
All right. So glad you guys are fine. Anybody else? Enthusiastic? Good. Okay. Awesome. Awesome. I'm doing well. Thank you for asking. Amazing. Okay. Awesome. Awesome.
Blessed.
Bless. I love that, Ed. Awesome. Okay. Wonderful. Great. All right, Calvin. Ramon said, great. Awesome. I'm glad that you guys are doing great. So, let's just dive right in because I want to get to everyone. We do have 60 minutes. So I'm going to share my screen here and I will just go through like the top 5 questions that almost everyone usually has. And then after that, raise your hand or put your question in the chat and I'll get right to it. So let me share my screen. All right. So let's
I had a
see.
question real quick.
Yeah.
Christine, is this being recorded?
Um, that's a good question. I guess not. Or is it? Oh yeah, it looks like it is. Hold on one second, let me see. It wasn't. I'll just press record. All right, now it's recorded. Thank you. All right,
Welcome.
so let me get to share my screen here. Let's see. Okay, let's see here. There we go. Sometimes I'm technically challenged. Okay, there we go. Okay, awesome. So let's just go through the top 5 questions, and then from there, I'll be able to answer your specific question, okay? So you can just throw your question in the chat or raise your hand because we're going to go through this fairly quickly. So the first question is, who can be the grantor? Now, when it comes to choosing your grantor, right, you have to choose because this trust is a two-party contract. So there are two individuals, right? You have the grantor and the trustee. Now, the nature of the trust is irrevocable, which means that the grantor has irrevocability, which means that they cannot administer or manage the trust, okay? So, because the trust is irrevocable and the grantor has irrevocability, that means that the grantor cannot make any changes. They have no power. They have no beneficial interest. They cannot remove the trustees or the beneficiaries. They cannot remove assets from the trust. They cannot terminate the trust. Okay. So their role is very limited to what they can and cannot do. And I'll go through that in just a moment. So, because they have irrevocability, you have to decide if that's the position that you want to be in. Now, the other position is the trustee, right? And so the trustee has, because they're the fiduciary, they have all of the power and all of the control. So they're going to administer and manage the trust, okay? So now, when it comes to who can be the grantor, right, you want to if you don't want irrevocability, then you have to choose someone else to be the grantor. So, because the grantor has irrevocability, the grantor cannot be the trustee, okay? Meaning that you cannot be the grantor and the trustee of this trust because this trust is irrevocable. So, unfortunately, you have to choose one position and one position only. So, you're either going to choose to be the grantor and have irrevocability, or you're going to choose to be the trustee and serve as the fiduciary. If you choose to be the trustee and serve as the fiduciary, then you're going to have the other person that's a part of this contract be the grantor, okay? Now, typically what you want to do, what best practice is for you to choose someone that you are not related to. Now, if you don't have anyone, so that should be your first choice. Now, if you don't have anyone that you're not related to, that is not agreeing to serve as your grantor, then you can choose someone that you are related to. The only thing is that you have to make alterations to the trust because of the grantor trustee relationship. So there's a section in the trust that says that the grantor and the trustee should not be related. So you have to edit that section, okay? So now when you are choosing a grantor, it could be a friend, a neighbor, it could be, it could be pretty much anyone. But your first option should be, someone that is at arm's length or has some type of distance to you, okay? So now let's move on to the second question. So the second question is, what are the grantor duties? So the grantor, they are responsible for three things. The first thing is they are responsible for executing the trust. Okay, so that means that they're going to have this verbal agreement with you. The verbal agreement is then going to be expressed on the trust contract, and then the trust contract needs to be executed. So that means that it needs to be notarized. So their signature is required on the trust documents. Okay. So that is their first duty, is to have the agreement and to sign and get it notarized that they have this agreement with the trustee. Okay. Their second duty is to put the first gift or the first asset into the trust. Okay. And so what we call that is the initial consideration. Okay, so we document that on the Schedule A of the trust. So the initial consideration is the first thing that has intrinsic value that you're placing into the trust. Okay. So this first thing, the way that the templates are designed is we are identifying this first thing of value to be $1. Okay. So it can be whatever you want it to be. So that is an example that you can very well use. Okay. So it can be anything that you want. So it can be any form of currency. It doesn't have to be USD, and it can be anything that has value. So it could be real estate, it could be an insurance policy, it could be cryptocurrency, it can be jewelry, it can be precious metals like silver and gold. Okay. So a lot of people, they will go and opt in for the US dollar. They will also change it to another dollar amount. And then they will also change it to precious metal or, other things. So just keep that in mind and know that it has to be documented on the Schedule A. Okay. So the next thing that that the grantor is responsible for is obtaining the EIN. So when we are getting an EIN, the EIN is not required. But if you want to open up a bank account for the trust, then it is highly recommended that you obtain an EIN because the bank is going to request it. And if you don't have it, then it is highly likely that the bank will not open up a checking account for your trust. So the grantor is going to be responsible for obtaining that EIN. And when you're filling out the SS4 form or the online application for the EIN, it asks for a responsible party. So the responsible party is the grantor. So it asks for two people, right? It asks for the responsible party, and then it also asks for the trustee. So the responsible party is the grantor, and the trustee is obviously the trustee. Okay, so you're going to have to go ahead and put the grantor's full name and social security, and you're going to have to put the trustee's full name. Okay. So those are the three responsibilities that the grantor has. And then after they are done fully executing the trust, they walk away from the trust. So they are not going to have any type of administrative task. They're not going to have any type of power or control over the trust. So they literally walk away from the trust after it's executed. Okay, so let's move on to the next question. So, whose social security is used in the EIN? So, a lot of people always ask this question. So, once again, when you are applying for an EIN, the name of the form is an SS4 form. Okay, you can do it either two ways. You can fill it out through the PDF and send it in through the IRS, or you can use the EIN assistant online and do it virtually. Okay. And if you do it virtually, then you'll instantly get the EIN. Now, when you are going to apply for the trust, they're going to ask you who the responsible party is, right? And so the responsible party, the information that the IRS wants in that section is the grantor's information. So they want the grantor's full name, so first name, middle initial or middle name, and last name. They also want the grantor's social security. They're also going to ask for the trustee's information as well, because the trustee's name, since the trustee is the fiduciary and responsible for the EIN, the trustee's name is going to be on the EIN letter. Okay, so you'll see that you're using the social security number of the grantor, but the grantor has irrevocability. So the IRS already knows that the grantor is not administering any of the terms and conditions or provisions for the trust. So when they issue the EIN letter, it's the trustee's name that is on that letter. Okay. So that answers that. Let me let some people in here. 1 second. Okay, so let's go to the next one. So can the beneficiary be a successor? So a lot of trustees have this question, and the answer is yes, right? So if you have a beneficiary, and as long as they are at least 18 years of age or older, then you can appoint them or nominate them as the successor trustee. Okay. And the only thing that's required is their name, address, and phone number. And once you nominate them, then they will stay listed there as the successor. Now, once it's time for them to then become the acting trustee, that beneficiary they can stay in that position to where they are the trustee and the beneficiary. So they can decide to remain in that duly appointed role, or they can remove themselves as a beneficiary, and those TCUs can go to their heirs, or it can go back to the trust. So that trustee at that time, once they take power, then they have to decide, what's the best thing for them, okay? So, but they can remain in both positions. So the next one is, can I transfer my house into a trust if it has a mortgage? So the answer is yes, right? There are no restrictions on if you can transfer your property into the trust, okay? So as long as you have the deed to your property, then you can transfer it. Now, everyone who is on the deed has to be able to sign saying that they are conveying their ownership rights to the trust, okay? So you're going to have to redeed that property into the trust, and then you're going to have to record it with the county, and then the county will reflect that the trust is the new owner of the property. Now, as far as the mortgage is going to remain intact. There's nothing's going to happen with the mortgage, okay? So it's going to remain intact. It is going to remain in your personal name. So there's no way for you to transfer the mortgage to the trust. It is going to remain on your personal credit report. So there's no way for you to transfer it to the credit report of the trust, if the trust has a credit report, okay? So the only way that you're able to transfer the mortgage to the trust is if the trust qualifies for a mortgage, and if the trust and the trustee decides that it is in the best interest of the trust to refinance that property and to hold the mortgage in the trust name. But that is not necessary. So typically, what you want to do is you want to contact the mortgage company to let them know that you are going to have a assigned what's the word? An assigned financial what is the word? Okay, the word is escaping me right now, but you're going to assign the financial responsibility to someone else, right? And so that's going to be another entity. So you would just update them to let them know that the mortgage payments are now going to be the responsibility of the trust, okay? So, so that's it. And let's move on to the next question. Oh, the other thing I wanted to mention was a lot of people, they get concerned with what is called the due on sale clause, right? Which is the acceleration clause. And so the due on sale clause is where a mortgage company can accelerate your loan or your balance to be due if you transfer the property to someone else. So that is only applicable if the property is transferred to someone else's name, meaning another person, right? Another living human being, okay? So it is not, the due on sale clause is not applicable if it's transferred to a trust, okay? So just keep that in mind. So the next one is, do I have to register the trust if it has a mortgage, right? So your trust is a private contract and it does not have to be registered with the state. So the only thing that you would have to do is just record the new deed, okay? And then once again, you will then update the financial responsibility with the mortgage company. So that is it. So we're gonna dive right into Q&A so I can answer any questions, any additional questions that you guys might have. So I'm gonna look in the chat here. All right. So, um, Coach asked, when you're creating a board, do you pay the board members? So that is a really good question. The board members, they are able to be compensated. So it is up to you if you would like to compensate the board members, okay? And so that is an agreement that you have to have with the people that you're nominating and appointing in that position. For example, if you're going to have a secretary serving on the board, then you're going to have that conversation with the secretary, what the compensation looks like. Okay. So inside of the trust indenture, it does specify that these individuals or members that are appointed in this position, they are independent contractors and that they are going to be compensated for their services. So the compensation, right, is not specified. So we don't know what the compensation is. So it's not saying that it is a specific dollar amount. It's not saying that it is in a certain currency. It's not saying that it is, monetary. Okay. So that is something that you're going to have to determine when you start to operate the trust. And it might be to where in the beginning, when you're setting up the trust, because the trust is starting at ground zero, that there is, no monetary compensation. But once the trust starts generating income, then there will be, a reconsideration or there will be um, delayed monetary compensation. So you have to make that decision based on what assets you're starting the trust with and what's in the best interest of the trust, right? What can the trust afford? Because it's not designed for you to take like money from your W-2 to then go ahead and pay a board. That's not what it is, right? So anything dealing with the trust, meaning any trust business or anything like that, that compensation needs to originate from the trust. So that was a great question. So I want to go to some hands and then I will be back in the chat. So I see Miss Rose. Hey, Miss Meredith Rose, how are you?
Hi, I'm really well. It's good to see you, Christina.
Nice to see you too, my dear.
Thanks. Here's my question. My nonprofit isn't a nonprofit yet because I didn't register with the Secretary of State or Attorney General in California. I've been trying to, but I haven't gotten the forms yet. So, what do I have an actual legal trust right now, even though it's not registered with anybody or signed by an attorney? What do I have right now, Christina?
Yeah, that's a great question. So you have a private trust. It is not a public trust. Um,
Right.
it sounds like you want to make it public, and you're able to do that. So as you mentioned, all you have to do is register it with the Secretary of State if you want to make it public. And we've had this discussion before, so I know that you do want to go down that route. And a lot of people, they decide to go down that route for various different reasons. So some of those reasons can be for federal funding, some of those reasons can be for grants, some of those reasons can be for public visibility. So it sounds like those are your desires. Now, what you have is a trust and it is a nonprofit tax exempt organization and it is legalized as long as you've gotten it notarized. So it is legalized and you are able to operate it. So it is a private organization. So that is what you have.
Okay, great. The EIN, if I don't want to file for a 990, because really my taxes, it works out just fine either way, whether it's a nonprofit or whether I just do it my own way. So the EIN number is going to expire in 3 years. So do I need one even if I'm not tax exempt? Do I need an EIN for the trust?
So that's a great question. The EIN is not required. So the only reason why we would obtain an EIN is for banking purposes.
Okay, so I do have a bank account and I do have a virtual post office that I pay for. So I don't really need that if I don't have the nonprofit tax exempt, right?
You don't need what, the EIN?
The virtual post office box. I mean, yeah, the other, like the post office box, iPostal.
So you want the trust to have its own address.
Okay,
You
great.
don't want the trust to use the address that you use personally.
Okay, perfect. One more question, if you will. So how can I go ahead then if I have an asset, or if can I put my like my Fidelity account into this trust, but be able to take funds out because it's not doesn't have the nonprofit status and it wouldn't be fraud, right? If it's just a trust, can I take funds out and put funds back in?
So the organization, you have to, so the type of organization that you have is a nonprofit,
Okay.
and you need to be operating it as a nonprofit.
Okay, Christina, I
Yeah.
get it.
So it goes based off of the nature of the contract.
Yeah,
And
yeah.
so the way that you administer any type of or take or like do any actions for that particular organization has to be in the way to where you're documenting everything.
Got it.
And it has to, you have to operate it the way that it is intended. So what is inside of the contract? So if you have any discrepancies on what you can and cannot do, always refer back to the governing instrument, which is the contract, and you have to read it, right? And see if you're able to do these things. Now, when you're asking about Fidelity, right, that is a brokerage firm, right? So are you able to have an account with Fidelity with that organization? Yes, you are able to.
But I couldn't, I mean, I think it would be fraud to take out funds to use for my own personal use for some reason.
You're right. You're not going to use, so
Yeah,
this organization is not designed for a person to benefit and for personal use. You're right.
got it. Okay, so last question then. If and when I want to put my Fidelity account into this trust, do I just go to Fidelity and give them the name? Is that all I have to do to transfer it over if and when I do that?
So you have to contact Fidelity to see how they want to do it. It depends on the
Okay.
type of account that you have.
Okay, great. Thanks a million.
You're welcome. And next we have Ethel.
Hello. Hi.
How are you, Ethel?
I'm good. I had emailed you a question. I don't know if you got it.
Oh, let me check my email. One second.
That was
Did
2 days ago.
did you send it to me or did you send it to the team?
I sent it to the email that you sent to me. I don't know. But anyway, I can repeat it. So I got confused when she said EINs expire. That's specifically for her nonprofit while she's waiting to get Secretary of State.
Um, so to my knowledge, I don't know anything about the EIN expiring. So
Okay.
she has had conversations with agents and that's what she was told. I don't know anything about that.
Okay. Okay. Now, when we do first, I did my iPostal, right? I did a business trust. I put the address, the working address for Wyoming. And I got my first mail that said something like workforce letter. And so I'm trying to wait for them to scan it to me. But because I registered, why am I getting mail from Wyoming's workforce?
Okay, so say that again.
So my iPostal has an address in Wyoming for the business trust, irrevocable. And I have a piece of letter that says it's from some workforce department in Wyoming.
Mhm.
I haven't opened it yet. I asked for it to be scanned. So I guess you ask for it to be scanned and then they'll send it to you.
Okay, so I don't know what's inside of the letter. So I don't know. You could share it with me. I'll take a look at it, but
Okay.
I
I'm
don't.
like, I thought I was hiding. So
Yeah,
how already are they finding me?
yeah. So I have no clue. I don't know where you put the information for the trust. So it sounds like you said that you only put it on iPostal.
Yes, because they needed my address. For iPostal, I put that address.
Hmm.
Um,
Did you open up a bank account?
I did.
I was gonna
Yes.
say it could be just junk mail. You know how you get junk mail all the
Right.
time, so it might just be junk mail.
Okay, yeah. So I opened up a bank account with Ally Bank. But it wasn't even for that business. That was for anyway, my next question. Once I open it, I'll let you know, but I was just perplexed about that. When I okay, my existing businesses are in rental properties or in my LLC. So my LLC is a public record now because it doesn't have my name, but then I also, for my primary home, have a living trust, a traditional revocable trust. So if I take the LLC and transfer ownership from the LLC to the business in the business trust that's irrevocable with the Wyoming address, and people already know that LLC is tied to me, then to me, I'm telling them where my new address is because it's not changing ownership per se. I mean, it's showing the new
It,
address,
it,
but
it is it is
the
changing
it's
ownership.
changing ownership,
Yeah,
but
it is changing
it's
ownership.
changing ownership. But a chain of title could go back and see that I used to be the owner.
That's
But in our
correct.
records also for real estate, it would show no transaction as far as a sale. So when
Mhm.
we do a chain of title, we kind of read what's going on. And I would know that, oh, they just changed the hands of it. It doesn't look like there was a mortgage. That didn't change. So then we go and I have my primary already under my name. So that's easy to find, right? You Google me, you can see you know where I live, and then you see that I have a family trust. So I'm thinking to be more discreet, since the LLCs have been existing for a while, with those existing ones, would I still be safe if I just transferred title from the LLC to my private trust?
So will you still be, so this is what you need to understand, which is it sounds like it is a concern, right? And so
Mm-hmm.
everyone should be aware of this, right? So what you're describing is skip tracing when people are able to trace back. Okay.
Mm-hmm.
So is it possible? Absolutely, right? Because everything is a part of the public records.
Yes.
So when you go to transfer your business, not transfer, but when you go to amend the articles of organization,
Mm-hmm.
the amendment is public records. People are able to see the amendment. People are able to see that you removed yourself and that there is now a business trust, right?
Mm-hmm.
So, and the business trust is now visible on the forefront that it is now owning the LLC. So the thing is that we do a business purchase agreement for our internal documentation to show that that it's a sale, right? That we sold the business, right?
Okay.
We sold the business, so we are no longer associated as an owner,
Okay.
right? So all of our ownership rights have gone to the trust. We're no longer the owner. So that's undeniable.
But that business purchase agreement is still private. It's only if you need to prove it.
Correct.
Okay. Private. Okay. Or should I just go and put with the, okay, I get that. So if I want to take my primary and do the same, I would change it from but my primary home is the private trust, and it's still revocable. Can I list on the business trust? I listed the family trust as the trustees, even though personally I'm also the trustee, but I list the family trust as the beneficiary, and I put myself as the trustee from the grantor. That's correct, right?
Yes.
Okay. Back to the primary home. It already sits as a Sims family trust. Am I not as protected if I don't take it out of the Sims family trust and put it in the business irrevocable Wyoming trust?
But why would you put your primary residence into the business trust?
You're right. You told us not to. Right. Okay. Just try. Okay. Keep them separate. Got it. So the main thing is the LLCs being, okay. So I did an operating agreement with my LLC, and I took myself off as managing member of the LLC. And I changed with the Secretary of State, the manager's name from myself to the business trust.
Okay, that's correct.
Now that, and then I changed my agent of service from me to someone else. So now that stopped the skip tracing on that side. But I'm still concerned about the LLC being, and I haven't funded it yet. So I'm scared to take it out of the LLC, put it in the name of the business trust, and then not have an account for the business trust on the bank account yet, because I haven't got an online yes from transferring to a irrevocable. I was easy to do an online with my family, but when I seem like I try to do an online account with irrevocable, it comes back, we need more documentation.
Yep. So it depends on the financial institution.
And I think that was even with Ally Bank.
I know.
They're all getting real skeptical, you know?
Yeah, no, it's just that's the policies when it comes to these banks.
And when I'm on the operating agreement for the LLC, when I go down to the last and I do my capital distribution, in addition to doing the amendment for the state, I made minutes to the operating agreement. And then I said the managers are no longer myself and my husband, but now they're the family trust for the LLC.
So why is it the family trust?
Well, who should it be if it should go be back to the new irrevocable one.
To the business trust. Business
Yes, to the business trust.
business.
Yeah, I keep getting myself mixed up. Okay, so
Family is family, business is business.
okay,
Primary residence goes into your family, the business, which is the
got it.
LLC, goes into the business trust.
Okay. I think the amendment said the right thing, but the minutes when I did the last page, I have two different heads on.
Yeah, so your operating agreement should have the business trust information listed as the new manager or member. Ethel, you're on mute.
Is that just the last page or suffice, or actually I can do an updated minute as well, right?
Yeah, so you should update the entire operating agreement.
Oh, really?
Yeah, so like the sections where you have the
Got it. LLC, I
manager.
got to remove that. Okay. Oh, okay. Okay, got it. So it's a brand new operating agreement, and it's justified by that business purchase agreement as well as what they would see on the state. Got it. Okay. Thank you.
You're welcome. All right, we're gonna go to Alexa.
Good evening, everyone. Okay, so I'm going to be honest, I do have about four questions, but because they came up with the other questions, hopefully they be really quick because I know other people have questions. So I'm gonna ask my most important one first. So I have my mom as the grantor for my trust. Um, she is the grantor, and when it comes to the business trust, I can see how there wouldn't be like, because she's so close to me, how there wouldn't be any conflict. But when it comes to the private family trust, my concern is there being conflict because she is so close to me and, her not being able to have any beneficial interest in the trust. So, um, and this comes from, you know, what if one day she has to live with me in one of the properties or use a vehicle that I put inside of the trust or, come to things like agriculture or things of that nature. So should I modify the trust so that it's not so absolute? So there's, limitations, but not just because I'm putting all of my, assets into the private family trust.
So that's a good question. So your mom, she like you said, she's too close, right? Because the whole idea is that you as a trustee should not have you should not be subordinate or subservient to the grantor. And so once upon a time there was a position or a point in time when you were subordinate, right, to that grantor. So she's not the best option, especially if you want her to benefit from the trust. Now, if the trust is already established, there's no way to replace the grantor, right? Because the trust is already established. So you would have to create a new trust with a different grantor.
And so I'm glad you brought that up. So can we, my question was, could you briefly explain the effective date versus the creation date? And then to your point about it being established, because nothing has been notarized. Only thing
Oh,
I have so far is just the EIN.
okay. All right. Sounds good. So the establishment date is the day that the verbal agreement happened between the grantor and the first trustee. So that means that the grantor and the first trustee, they sat down, they talked about it, it was oral, and then that verbal agreement was then expressed on the contract. So the establishment date is the day that that actual meeting happened. And then you have a separate date, which is the date that it actually gets notarized. So that date is different from the establishment date. So you are, whenever you're performing a task for the trust and they ask you for a date, you're always going to refer to the establishment date.
Got it. So that's the creation date is the same as the
Mhm.
establishment date. But
Yes.
it doesn't, so what would be the difference though between the establishment and the date that is deemed effective, like legally? Like, so I understand one day is just the day that, okay, we came up with this agreement, but the effective date is just basically when it can actually be enforced, essentially.
Yep. When it's notarized. Yep.
Okay. Got it. And so then I know earlier we were talking about addresses. So what exactly is the process if you wanted to change the status of the trust? Updating the trust certificate for banking purposes and things of that nature.
Yeah, so after the first one is executed, then all you have to do every single time that there's something that changes, those sections outside of the indenture are they're like living documents. So like the certificate of trust is a living document that's designed to always be updated. So you would just update it with whatever the change is, but you would get it notarized again. The second one is not going to require the grantor signature.
Got it. And we would have to bring the first one with us.
Yeah, you don't want to discard any of the trust documents. So you're always going to, have it within the trust records.
And so I don't have to change, like on the heading page where it says the state republic and inside of the indenture where it has the codes for the specific states, those don't need to be amended as well.
Yeah, so you're gonna have an amendment to the indenture, but you're not gonna actually change like those pages.
Okay.
So you're always going to refer to like the solution, the resolution that you passed. So you're going to have an amendment and you're going to describe whatever the amendment is. So if you're changing the domicile state of the trust, then you'll go ahead and document that.
Got it. Perfect. And this was the last one. So we've been talking about the LLC. Um, so I know in the training you showed us, and excuse me if you did go over this, but I'm just a tad bit confused about it. The training, I remember you showing us how to change and update the owner of the LLC at the trust creation. But um, just so I'm clear, when we want to add a new LLC to an existing trust, all we need is the purchase agreement. And then will we still just record that on the Schedule B and the minutes?
So yeah, you're gonna record it on the Schedule B. You're gonna have a board meeting, minutes about it. You are gonna do the business purchase agreement and you do have to do an amendment to the articles
And a
because,
minute.
because you legally have to put that LLC in the trust, because if you don't do an amendment to the articles, then legally the LLC is not inside of the trust.
Okay. Thank you. That was all my questions. Thank you so much.
You're welcome. All right, next we have Raul, and then I am going to go into the chat.
Can you hear me?
Yeah, perfectly.
Hello.
Hi.
So I try to do art when I can, and can I name the trust after my name for one thing? And then the trustee is sort of like an assistant, more or less to the trust. Um, so this person would be handling all the bills. Does this person purchase my art supplies, stuff like that?
Yeah, so the trustee is the authorized representative of the trust, okay? Because the trust, needs somebody to run it. So,
Right.
so yeah, so whatever equipment that the trust needs, the trustee is able to purchase any supplies, equipment, or anything. So they're dealing with all of the financial needs of the trust.
Okay. And I can name it after my name also.
Do you, is that what you want to do? Like,
Well,
is that for
as
a
an
specific?
artist, as an artist, you sign your name on the artwork. So,
Yeah, so for a situation like that, then of course you're able to do that. So people have very unique, different reasons
hmm,
why they would name a particular entity after themselves. So for your reasoning, that is in alignment. Yes.
okay,
Mhm.
great, thank you.
You're welcome. Next we have Jason. When you're creating, let's see, quick claim deed. Hey, Jason.
Hello?
Yes. Hey, Jason.
Hey, how you doing?
Great. How are you? You're still on mute.
Can you hear me now?
Yeah, perfectly.
Yeah, sorry about that. I had two. You was talking about the grand tours. Uh, are you kind of like leaning towards that we should really find someone, like you said, not related to us? Because my thing is, if we find someone that's not related to us, how does that affect if they had, just say, if I use you for example, we're not related, you know, and to say that you owe some taxes or whatever, and you're my grantor, uh, can the IRS still come after me, or how does that work? If someone is your grantor and has a lot of taxes owed or whatnot?
Yeah, that's a great question. So inside of the trust, right, it says that we cannot do we cannot take any actions for the trust that would actually put this situation, into existence, meaning that the the grantor's taxes are not supposed to, the trust is not subject to the grantor's taxes, right? It's the same thing with the trustee. So if you, as the trustee, have your own personal taxes, the trust is not subject to your personal taxes. So the trust is not subject to the grantor's personal taxes either. And the trust is only subject to their own personal taxes. So it all also depends on how you're operating the trust too. So that's why it's irrevocable to where the grantor doesn't have any type of power or control because any creditors, including the IRS, cannot come after that trust because the grantor has irrevocability.
Okay, that sounds pretty good. So if the trustee, like I said, the trustee has back taxes or any creditors coming after him, that won't affect the trust either, correct?
Correct.
Okay, my second question is, if we put our primary residence in the ministry trust uh, that we live in, how does that work if we still have a mortgage and we're making mortgage payments on it? Does the ministry trust pay all the mortgage payments and all the other expenses that like utilities or whatnot that deals with the home? And is that a tax write-off also?
So the answer is yes. So whatever trust that you decide to have be the owner of whatever property that you decide, whatever is associated with that property is now the financial responsibility of the trust, meaning that the trust is responsible for mortgage, for property taxes, for maintenance, and for utilities. And because it is an asset of the trust, those things are deductible.
Okay, and then with the ministry trust, I believe that you spoke on this. If we put our primary residence in the ministry trust, we can apply for the tax exempt for the property taxes. Is that correct?
So I personally would not tell anyone to put their primary residence into the trust. So I always tell everyone family stays with family, meaning that if this is your primary residence where you live, right, then it should go into the family trust. So the ministry trust is for nonprofit, philanthropic, charitable things. And if your family trust doesn't have anything to do, excuse me, if your primary residence doesn't have anything to do with that, then it shouldn't go into the ministry trust and it shouldn't go into the business trust. It should go into the family trust. Now, the only assets, specifically real estate, that you want to place into the family trust should have some type of nonprofit activity that's happening with it, right? And so if you're going to place a property into the ministry trust, right, and you want to apply for property tax exemption, you can qualify. So you can qualify. You do have to apply with that specific county. Now, that specific county is going to ask you for some type of proof, right? They want to know what the nonprofit activity is. And so you're going to have to let them know what that is. So are you running a church? Do you have like a farm? Is it like, a housing institution? Like what is it? What is the nonprofit that is being ran from that building? So just keep that.
Okay, because you just can't just. Oh, okay, so you just can't just say that you just donated your primary to the ministry trust.
You can do that. You can place it into the ministry trust if you would like to, but you have to understand that that is, a nonprofit. So it should be associated with it. So if you are wanting to just donate it to the nonprofit, you can. But as far as qualifying for property tax exemption, that you have to actually show that there's nonprofit activity, some type of, you're running an organization out of this place.
Oh, okay. I understand now. I understand. So it's best to put in the family trust. We put in the family trust, then all the expenses are tax deductible out of the family trust for the mortgage, utilities, etc.
Correct.
Okay. Okay. Awesome. Thank you very much.
You're welcome, Jason. All right, let's see here. So, Alton has a question, and I see your question in the chat. Alton, you want to come off of mute? On the family trust, where Article 14,
Sure.
6.
Uh,
Yes.
So the question was, being married, and I did say in the article, I think it's 14, section 6. So when it comes to putting down your family, when you're married, you put your one family name there. That's pretty much
You can put multiple. It doesn't have to just be one family name. So you can put multiple names there. So if you want to put two family names, you can.
okay because I wanted to have clarity on that. I just didn't
Yeah.
want to put two different family names on there. That was
Yeah.
my question.
Okay, yeah, you can put multiple.
Okay, great. Thank you. That's the only question I had.
You're welcome. All right, Calvin has a question. So how important is the meeting notes? So the board meetings is the life of the trust, right? So just think about the trust having a body, right? So if the trust has a body, that body has veins, arteries, and blood flowing through it, right? And it keeps that body alive. That's what the board meetings are. That is how important the board meetings are. So everyone should be having meetings for their trust, okay? We do have the templates available inside of the resources section so that you guys can easily navigate through the board meeting so that you can document like what major things that you are facilitating for the trust. For example, if you go to open up a bank account, you should document that. If you're going to go and transfer property like real estate, you should document that. So those big things need to be documented in the meeting. So are the board members automatically co-trustees? No, they are not. So this is one of those questions that we get frequently, which is sometimes people think that because the name of the board is Board of Trustees, that the members are also trustees, which that is not the case, okay? So those members that you're appointing as secretary and treasurer and general manager, they are members of the board. They are operating in a non-fiduciary capacity. So they are task oriented to where they are just fulfilling whatever duties that they have. So they pretty much, when you are putting your board together, you are choosing people that are going to hold you accountable and they're going to help you run the trust organization. So they are not trustees at all. So anyone who is going to hold the title as a trustee, they have to be appointed. And so the only person who can appoint a co-trustee is the first trustee, which is you. Do you have any recommendations to generate funds for the family trust while keeping it private? So, my recommendation always is to be able to get funds from the bank. And so you want to use one of those public entities, right? So I don't know, Calvin, if you were able to catch the masterclass that we did at 12 o'clock, but our funding manager came at 12 o'clock and he showed us how to get funding, right? And so you want to use public entities. And then from that public entity, you can issue out a loan to your private entity so that your private entity can use the money. So that is how you are going to keep your private entity private and not be subject to having to, establish a credit profile. Because what I want everyone to know here is that if you establish credit for the trust, right? The trust can build credit. If you establish credit for the trust, then at that time you are going to be pulling that trust into the public and you're going to be giving it a public record and it's going to have a public profile and now it's going to be visible. So someone asked if in the 508 a donation of 70,000 comes in, can you later make a $50,000 loan or gift to the donors of the IUL? That's a good question. So in the 508, you are able to give out loans. So there is no real restriction. So inside of the 508, it says that the restriction would be 15% of the total deposits from the previous year or upwards of $250,000. Those are sections within the trust that you have to customize. So you can either leave it at 15% slash 250,000, or you can change it to whatever number is more in alignment with your organization, okay? But yes, the organization can give out loans. The organization can own IULs. Do you have to do a purchase agreement when making a business trust the owner of an established LLC? Yes. So we have the templates inside of the portal in the resources. So you want to go ahead and fill out that business purchase agreement to show that you are relinquishing all ownership. So inside of that agreement, it is documenting, and that's the only reason why we use it is for documentation purposes to represent that we are relinquishing all of our ownership rights to the trust, right? And then we are also no longer liable for the LLC, and the buyer, which is the trust, is now taking 100% liability for that LLC. So it's inside of the business purchase agreement and we use it for documentation.
Wow.
So, so Kimberly's asking if I need to change my grantor, can I do the 8822B? So the 8822B is if you want to update any information with the IRS, meaning the responsible party and the address. Can you provide the sample business purchase agreement? It's already inside of the portal. So if you go into the portal and if you go into resources, you will see the business purchase agreement there. You can also send us an email if you are unable to find anything, and then we're able to help you that way too. If you transfer a house to the family trust and then change responsibilities of utilities, does that now make it public? That is a really good question. So you have to understand that the name of the trust is going to be visible. Why? Because the deeds, right, to your property are visible. They're on the public records. So if I wanted to get access to your deed right now, I can, because I'm just going to go down to the county and I'm going to put in your address and your deed pops up, right? And so whoever's name is on the deed, you can actually see it, right? And so now it doesn't make it public to the point that people are able to see all of the pages, right? It's just that the name is visible on the public records. Okay. So there is a difference. So what makes the trust public or private is if you register it with the state, because then at that point you're able to see all of the pages of the trust, right? And so if your trust is not registered with the state, then it is private because no one knows of the contents of your trust, only you, right? If your trust is 50 pages, no one knows what's inside of those 50 pages. Okay, 1 second. Private equity, is that Cynthia?
No, it's Tosh.
Tosh, okay. Hey,
Hi.
Tosh.
My question is, I mean, sorry. Stop it. Hello?
Yes, I can hear you.
Oh, sorry. I wanted to know, I know we had the recent meeting with Giovanni. I wanted to know if there's any way to repair credit quickly and then to buy a house in a trust instead of buying it with my social. Is that possible?
Oh, okay. So when you want to purchase property with a trust, the trust has to qualify for the mortgage. Okay. So if you don't have any, if the trust doesn't have proof of income, then the trust is not going to be able to qualify. So the way for a trust to qualify for a mortgage is by being able to show those 1041 tax returns, as well as bank statements. And so if you don't have those two things, that shows that the trust is able to pay back a mortgage, then you're not going to be able to qualify. Okay. And so a lot of people, because they're not at that point yet where they have even filed or they have substantial number of bank statements, then if they wanted to buy the property, now, then they would go to the extent of qualifying personally.
Okay. I think that's it. And how can I get in contact with Giovanni?
So, I can give you his Instagram. Do you want his Instagram? And then you can send him a
Yes, please.
okay, and then you can send him a DM. Hold on a second. Let me see. You're welcome. Okay, let's see here. Reba, you have a question? I think we're down to like the last few questions here.
Yes. My question is about the grantor. In trying to get to the bank, open a bank account, I went to Truist and they wanted a profile of the grantor, which would be his social, his address, his driver's license, and email. And he wasn't comfortable with giving them the social because he thought it was the trust is opening in his name. Is this does a lot of the banks ask for the grantor's information in order to open the trust?
Some of them do, yeah. Not every single bank, but some of them do. So I know Ally Bank does. I know Truist Bank does.
Okay. So does a lot of people have a I know you want to be private, you create the trust and you want to walk away from it. And I guess it does feel like there's a trace of you there that could be tracked. And so some people are just not comfortable with that.
I agree with you.
So I guess I just have to try and find a bank that doesn't require the grantor to come in or ask for his demographics.
I agree with you. So, you might want to try the credit unions because a lot of them don't, from what I've seen, they don't require like the trust documents and they don't require too much personal information.
Oh, okay. Okay. I'll do that. One of my concerns, like I did a lot of research in trying to find a bank that has a history that's been around a long time, because I don't want, when they have all these buybacks and the bigger banks buy up the smaller banks. And I was looking for a bank with some longevity so I don't get caught up in that. Should I be concerned about that?
About the longevity of the bank?
Yeah.
I think that you should absolutely like you are the one who have to decide which financial institution you want to establish a banking relationship with. And so those are things that you want to factor in.
So if a bank goes under and you have a trust with them, I mean, what do they allow you? Does it automatically go to the one who buy them out, or do they allow you to now move it somewhere else? I mean, do they even consider you? That's what I'm wondering.
So if the bank is bought out, then everything, is transferred like internally. Like
Okay.
so it honestly, to be honest with you, like it really depends on what that situation is, right? So if
Mhm.
they being bought out or are they filing bankruptcy? Well, like what is it that they're doing, right?
Mhm.
So at the end of the day, if it's just ownership, then you'll have, a bank with a new name, but your account is still grandfathered in.
Okay. Okay. Thank you. Oh, another question. So the meeting to open the bank account should occur before you go and open the bank account, correct?
The board meeting?
The board meeting, yes.
Yeah. So inside of the resources, we have a template available
Yes,
for,
other template. But
yeah.
like what happened with me now, so now I have to go and do another board meeting because it was not successful.
Yep. Yep, you have to update it. You have to update it so you'll have a second board meeting to say where you actually establish the checking account or the banking account.
Okay, thank you.
All right. Another question is if I move to another state, I keep my postal address in California and amend the trust documents. Anything else? So if you personally are moving to another state, that's separate from the trust. So it doesn't mean that the trust is moving, but if the trust is moving, then what you would have to do is you would have to update the domicile of the trust. So the trust can stay wherever you established it. But if you are changing the state, meaning, hey, I'm moving and the trust is moving with me, then at that point, you're going to have to update the domicile of the trust. So you would process an amendment to show that the primary residence of the trust is moving from California to another state.
Thank you.
Um, So I have a question here about the registered agent. Do you mean that the RA for the business trust and the family trust, or is it the RA for the LLC? So we were talking about the registered agent for the LLCs. Is this meeting being recorded? Yes, this meeting is being recorded and you will have access to the replay. Do you have to list the accounts, slash lawyers by state, that you would recommend? Um, so, we do have, um, a CPA and we can send you their information. And then, as far as an attorney, we recommend that you do your due diligence and find your own personal attorney. Which trust is best to put the IULs? So those life insurance policies should go inside of the family trust. They can go into any one of the trusts though. But typically we'll place it into the family trust. Okay, so we are down to the last three hands, and then we are going to adjourn the meeting. So if you already have a registered agent for the LLC, and we just continue with that registered agent, yes. Yeah, so we were saying, in a previous discussion here, we said if you previously were the registered agent, you want to remove yourself. You do not want to be the registered agent. So if you already have one, then you're fine. So do you need a registered agent for the trust? You do not. So the trust constitution in the 508, they are in that constitution, it asks for a registered agent. And that registered agent is the trustee, but that is internal inside of the indenture. So it's not external like how you would have it on the Secretary of State. Kyrie has a question, then we're going to Jason and Ricardo, and then we are all done with our Q&A for today. So Kyrie, did I answer your question or do you have another one?
Yeah, I have a question and a statement.
All right.
Okay, my question is gonna sound ridiculous. I don't know if you ever had somebody make a mistake like this, but when I was doing my 508, I made a mistake and put the name of my family trust in it.
Oh.
So I have my EIN, but how long does it take the state to get back with you to fix that mistake? Because I wrote them a letter and I sent them my certificate of trust showing what the name is supposed to be. And I've been waiting for a minute, like over 45 days to get a response from them, and I still haven't heard anything. Is it best I start it all over again or just continue to wait?
Okay, so you already have is it your EIN or what do
The
you,
EIN I
it's
have,
fine?
like I established it for my 508, but I made a mistake and put my family trust name on it. So it has the wrong uh entity name on
Oh,
it.
okay, so did you fill out the 8822B?
No, I
Okay,
didn't.
so fill that out and update it with the correct information.
88 two
22B.
two B 88 two 88 two B. And where do I find that at?
Just Google it.
Okay, just Google it. Okay. My second thing is more of a statement. So, I've been hearing a lot of people speaking about how these banks be questioning the grantors and stuff like that, want all this information on it. But the banks are like bullies. They're not going to tell you everything. When a bank is asking all that information on your grantor, that's only for their records purposes because the state don't require that information. The only time they require the information on a grantor if you're creating a revocable trust. So because our trust is irrevocable and you want to keep it private, the bank will try to bully you and tell you, hey, we need the grantor's social security number. We need this, we need that. A lot of the banks that everyone's talking about, I have let my sister's attorney, okay. I have let my sister, I say, hey man, I need you to find out something from everybody been having problem with setting up these trusts and these banks want all this information. Can you talk in your voice to these people and see what they tell you? And the information she been coming back to me from Fidelity to Truist and all the rest of them, allies. She said, no, that's just information for the bank's purposes only. But there are some stuff that they want to know, but it pertains only to the beneficiaries or the trustees, not to a grantor, because that's private information. They have no responsibility after being a grantor of a trust. That's it. They relinquish all responsibilities after that.
That's great information. Thank you, Kyrie. And so, everyone should know that when they go to establish these accounts, they can refuse to provide that information. And so it's up to the bank if the bank wants to give you an account or not, with the information that you provided. Next we have Jason and then Ricardo.
Yes, I want to bobtail off of what he just said. So if I go to Ally or Truist, if they do ask for my grantor social security number, they just want it for information purposes. They're not going to actually put his social security or her social security number on the checking account. Is that correct?
That's correct. So the grantor is not even going to have access to the account. So it's all the information that they're collecting is internal. So it's for, whatever established procedures that the bank has. But the only information that is going to be associated with the account is the trust information and the trustee's information as the authorized signer for that trust.
Okay, and then my last question is about the LLC. So with my LLC, if I put it into the business trust, uh, you say I have to do a purchase agreement, or is that the same as assignment, assigning the LLC over to the business trust?
I
What's the
mean,
difference?
yeah, so so it's almost the same thing. The only difference is that if you're assigning it, you're still giving your ownership rights versus a purchase agreement. But with the business purchase agreement, you're documenting that you're no longer liable.
Okay, so if I assign it, it's still, you said it's still like the same thing?
It's still like the same thing, but it depends on the verbiage that you're using for the assignment agreement, as far as liability. So are you saying that you're no longer liable in the assignment agreement, or are you still going to maintain some type of liability? So that's the only difference.
Okay, so if I do the assignment, does it still have to go through, do I still have to send that to the state?
No, you don't have to send it to the state. This is for your documentation. This is trust documents.
Okay, so with the assignment, I don't have to do that, but with the purchase agreement, you say you do have to report that to the state, or is that still the same? I don't
No,
have to report
no, no,
that.
no. No, that is internal. The only thing that goes to the estate is the amendment. When you say assignment, are you talking about an amendment?
Well, I'm just talking about if I sign my LLC 100% to the business trust, because the reason why I'm asking this question is because how do you get uh, like business credit cards and lines of credit, which I have through the LLC, but if I assign it or sell it to the business trust, are you still able to get those things, or how
Yeah,
does that work?
absolutely. There's no difference. It's still an LLC. You're still able to get it. So the
Okay,
only
even
the only the only difference is that now you're going to be controlling the LLC through a trust and not through your personal name. That's the only difference. That's the only thing that changes. So
so
now
how do
instead of you signing as a member of the LLC, now you'll sign as a trustee.
Okay, can you give me an example of the LLC being in a business trust, and then you apply for a credit card online, say with Bank of America, and you're trying to get a Visa or MasterCard. So do you just put the LLC, or do you put the name of the truck business trust on the
No, you
online
put
application?
so you put the information of the entity that's applying for the credit.
So the LLC, correct?
Correct.
Oh, okay, okay. So how does Bank of America know that it's owned by the trust?
They can see it on the Secretary of State. It's public records.
Okay, got you.
So
Okay.
that's why it's important for you to do that amendment. If you don't do the amendment, then the trust doesn't own the LLC.
Oh,
So you
okay. So
have to go all the way to the state.
okay, got you. Okay. All right. Thank you so much.
You're welcome, Jason.
Uh,
All right, we're down to the last question. Ricardo.
Again, Christina, what a great class.
Thank you. I
So,
appreciate you so much. Thank you, Ricardo.
yeah, you're a wealth of knowledge, so I'll keep on following.
Yay.
So I've been up and down with iPostal One since last week, emails back and forth, and I'm still trying to open this account, the business account. My question is, now they want a physical address for the business. And since the trust was going to be the business, um, is that going to be, part of the public record where the business name is going to be showing and an address?
So nothing on iPostal One is going to be public.
Okay.
So when you're applying for your account, everything is internal with them. And they need a physical address because they're going to forward the mail. So they can't forward the mail nowhere. They have to forward the mail somewhere.
The thing is, well, I already put a PO box for the mail forwarding, and they
Mhm.
accepted that. What
Mhm.
they need now is a physical business presence, an address for the business.
So did you tell
So,
them that there's no brick and mortar for the business? That's the whole
mm,
reason why you're getting a iPostal address, because the business doesn't have a brick and mortar.
no, I did not tell them that, and they want me to fill out that form again, the 1583.
Mm-hmm.
And without a physical address, they will not open an account.
Okay, so you're saying that they're not that they're rejecting your PO box. That's what you're saying. Is that
Well,
what's
they want that brick and mortar or a personal address for
okay?
some reason for the
Yeah.
business.
Okay, so two things. One is iPostal is a company, their policies and procedures and what they require in order to render services to you is what they require. So I am not familiar with if they don't accept PO boxes or not. Now, an alternative, I'm not sure if you've tried this, is with some of those PO boxes, you have to get like a shipping address. And so they'll give you like the street address, and then you'll have your your PO box as like the suite number.
Yes.
So that's an
So
alternative.
it
I don't know if you've ever tried that, but that usually will assist you with bypassing.
yeah, but it specifies and clarifies that they don't want that either.
Okay,
I
so
can
then
forward you the email so you can read it.
yeah, but at the end of the day, it's their policy. They're rejecting the PO box. So they're saying that
Yeah.
they're not going to forward it to a PO
No,
box. And-
they'll forward the mail to the PO box. They just want an address, a physical address for the business, since
okay,
I'm applying for a business
right.
mailing with them.
Yeah. So that um you
So
know that everything is happening through USPS. So that could be probably a compliance issue in order for them to comply with USPS.
okay.
So
So would it be fine if I just put my home address, or should I just rent an external office space like they were talking about earlier, just for that purpose?
I mean, it's up to you. It's up to you.
Okay,
Yeah.
sounds good. That was my only question.
I just talked to iPostal on there, and that 1583 is a USPS requirement in order for you to receive messages there, letters and stuff.
Yeah.
So that's what they're asking for.
Yeah. It's
Yeah, the reason why I was asking is because they're just drilling down on that business physical address,
Mhm.
and that was the whole purpose of why I'm opening it. I'm opening this virtual address because I don't
Mhm.
have an address. I'm applying for an address.
Mhm.
yeah,
So
yeah, they probably want your home address or like, a location.
the
So,
location just for the business.
yeah.
Sounds good. I'll keep on making some homework and see if I can come up with something. So I
Yeah.
won't have to put my personal.
And if not, don't afraid to go to other companies too, right? I postal one is not the end all be all. I just like it because it gives you, a lot of options and not only domestic but also international. So you might want to like Google other places near you, right? There's a lot of like, local places that they do the virtual address services.
Oh, okay.
Mm-hmm.
Sounds good. I'll go ahead and try that then.
All right, sounds good.
Thank you, Kristen.
So, thank you, Ricardo. We are all done for today, you guys. This was a great 90-minute Q&A session. So, I hope that I answered everyone's question. Well, she's stepped away, but can you hold on, I see another question.
Maybe he needs to get a co-working space.
Oh yeah, that sounds good. Yeah, I think that sometimes this requires us to be a little bit creative. So don't be afraid to be creative.
Get a what kind of space?
He said co-working like
It's like a shared space. If you
mhm.
need desk space, you can find desk space somewhere. Co-working. I don't know what state you're in or city. They're popping up all over the place these
Yeah, they
days.
sure are. They sure are. Very innovative.
Okay, thank you.
But Christina, someone did write in the chat, where can we find the recording at, if you don't mind sharing?
Yeah, so well, I'm gonna go ahead and put the replay link in the chat. 1 second. And let's see here. Replay link. So the replay link is inside of the chat so that you can watch it from beginning to end. And so we're all done, you guys. So I hope that today was valuable. I hope that I was able to answer everyone's question. And I hope that this call provided clarity because I know sometimes when we don't have that clarity, then we can feel a little stuck and unable to move forward. And so this is a journey, so I want you to give yourself some grace. I don't want you to rush through this process. I want you to be able to take all of the necessary steps in order for you to build this solid foundation. So just, take your time because you know how they say Rome wasn't built in a day, right? You can't build a house in 1 day. So the foundation is the most important part. And you establishing that trust is the most important part. So everything else will come with time. But I'm so proud of all of you guys because it really does sound like you're moving the needle forward with getting your trust notarized, with getting your virtual addresses, ready to establish credit. Some of you guys have bank accounts already, so I am extremely proud of the progress that you guys have made so far, and you also need to be proud of yourself. So we are here to hold you accountable. So if you need anything from us, just let us know. So you can send me an email. My email address is Christina@sevenwaystowealth.com. You could also send my team an email. So Ivy's email is info@sevenwaystowealth.com. And whatever you need from us, we are here to assist you. Okay? How often are the Q&As? So right now we have them scheduled for once a month, and they are scheduled for, I guess, the third Thursday of the month as of right now. Sometimes we'll have some pop-up Q&As from here, just depending on how many, questions we have. And so we want to be able to give you those answers sooner rather than later. So that's why we have these Q&A sessions, and I'm so glad that you guys were able to make it this evening. So they're going to be every third Thursday of the month. Our workshops are going to be the second, either the first or second week of the month. So right now we have them scheduled for the second week. So those of you guys that are going to attend the next workshop, it is going to be February 9th to the 13th. And then we have a couple of master classes. So this week we had 2 master classes, and next week we will have a master class for you. So the team will let you know what day and time. So next week we're sticking on to real estate. So we're going to be talking about wholesaling. So this week we had spoke about the mobile home investing. I hope that you guys were able to attend that. If not, we have a replay for you. Yep. So all of the master classes, they are available on our YouTube channel. So if you go to our channel, then you can find it there. And hold on, let me just grab it. I'm losing my train of thought. One second. Let me grab the channel. I'm gonna put it in the chat right now. So here it is. So they are available there. And then we also have a portal for it. So I'm going to check with the team so that they're able to put it inside of our Telegram and our Facebook community. Another thing that I want you guys to know is that we have recently rolled out a Q&A bank. So, meaning that it is one page where you can click on this link, and there's a search box, kind of like Google, and you go and put your question there. And then the answer, as long as we have the answer to that question, because to be honest with you guys, almost everyone has the same question, right? Yeah. And so we have collected, so from all of these Q&As, every single Q&A that we've ever done, we have collected all of the questions and answers, and we put it into a bank. So, let's see here. So I'm gonna have the team provide you guys with the link to the bank. And then Ivy put the link to the calendar too. We have a lot of links for you guys. We should just rename the community and call it the link community. We're just gonna give you all the links. So we're trying to just make this a smooth process, because believe it or not, there are 2,200 trustees in the community. So it's a lot of you, and there's not that many of us. So we're a team of pretty much 5, and we just do what we can. So Ivy just put the link to the calendar, so that's where all the events are. So we're going to update it with all of the master classes that we're going to be rolling out, but you can see all of the Q&A and workshops there and any in-person events. And then we're also working on a abroad event too. So last year we went to Ghana. So this year I am looking at an opportunity for us to go to Morocco. So I will let you know sooner rather than later because our traveling is going to be pretty much in quarter 4. So I'm going to do my very best to have everything finalized so that I can share it with you guys sooner rather than later if you guys want to go to Morocco with us. Or if it is Morocco. So I'm working through it. Me and the team, we are diligently working through it. So that we can have another opportunity to go abroad as a community. So, those are all of the exciting events and things that we have coming up. So, I will see you guys here next week when we have our masterclass on wholesaling. So, for all of you real estate investors or potential real estate investors or anyone who wants to learn about wholesaling, you definitely want to be in that class. Nikenji, do you have something? Because I saw your hand just creep up in there in the last minute.
Yeah, I got a quick question. I think I probably asked and I forgot it and thought things was gonna happen beforehand, but divorce, changing my name. Should I set up the trust now and then try to change all the trust papers, or get the divorce first, then change my name and then do the trust papers?
You haven't executed the trust yet?
I haven't. I was waiting to get my divorce, but it's taking longer than what I thought it was gonna take.
Oh, okay. Well, that's fine. So all you have to do is have an amendment and you put that the trustee changed their name, their legal name, and then you're going to document what it was and what it is.
Okay, so I
Mhm.
don't need any other documentation or like social security card information. No.
No, so if I were you, I would just add the divorce decree into the trust documents, and then you're going to update the certificate of trust.
Okay. So I'm thinking I probably need to go ahead and do this now and then just update the trust later on so that way I can go ahead and get things in order.
Yeah, absolutely.
I've been procrastinating, waiting. I thought it was gonna be done so long ago.
Yeah. Yeah, don't worry. I'm divorced too. I had to do exactly what you're doing. So girl, I'm right with you.
Okay, thank you.
Mm-hmm. All right, guys. So good night. I love you so much, and I will see you guys next week. Hopefully, it's going to be on Tuesday. So I will see you guys next week, and we are going to reconvene for an amazing master class.